Samaj and what is the order of the High Court?
There was before vacation एक order pass केली High Court setting aside the order of the inquiry officer by saying no proper show cause notice was given. आणि ती show cause notice High Court सांगले परत दी म्हणून आणि inquiry to be conducted by the officer and to be concluded within 2 weeks. आता कितें जाला तेणे show cause notice काढली हे लोकांनी डॉज केली. हांव म्हणटा डॉज कित्याक ऑफिसान सगळे नोटीस पावयलोले आनी आयले सांगपा आमगे घाराको पावलो ना म्हण तुम पळय अशें आनी मागीर हे सायडीन एप्लिकेशन घायली हायकोर्टान मागून की हे ऑफिसराक काड म्हूण तेका डायरेक्शन दी म्हूण प्रॉपर शो कॉज नोटीस काडपाक आनी तेजेर कंटेम्प्ट ऑफ कोर्ट इश्यू कर म्हूण पिटिशन एप्लिकेशन आयिल्ली आनी हांवें ओपोज केली. हांवें सांगलां असले एप्लिकेशन आर नॉट मेंटेनेबल because petition once it is disposed you can't ask clarification, modification or anything you cannot ask after a petition disposed. I Supreme Court order of 2024 लायली आनी दाखयली कोर्टाक. हांवें पासून सांगलां की नोटीस दिली तांकां आनी ते आज सांगतात ते पावल ना तो म्हणटा ना देर वॉज मिसअंडरस्टँडींग म्हण देर वॉज नो मिसअंडरस्टँडींग हेची कानारी करताले. सो एनीवे सद्या कितें जाला दॅट इट इज एप्लिकेशन जज हर्ड मागीर ते लास्ट मारपा लागलो आनी कसले प्रेयर्स क्लॅरिफिकेशन दी म्हूण कोर्टान म्हणलो कांय क्लॅरिफिकेशन दिना आनी सोमतो तेंगे एप्लिकेशन डिसमीस जाला. आतां रिजल्ट ऑफ दीस इज दॅट ऑफिसर तो डिस्ट्रिक्ट रजिस्ट्रार आहा तो ही इज कॉम्पिटंट एंड ही कॅन कंटिन्यू विथ द प्रोसिडींग्स. Number 2, these people wanted time to be extended for the proceedings. Court refused to give. म्हाका दिसता टायम मागतले तेंगे रिप्लाय दिवपा आनी बेश्टे डॉज करपा आनी फुडें फुडें दुखोवपाक तो पूण कांय जालें ना. आतां ते टायमान दिनात जाल्यार वी वील प्रेस दॅट इट शूड बी कंडक्टेड एक्स पार्टे आनी डिसिजन मागीर ही वील पास इन अकॉर्डन्स विथ लॉ. सो दीस इज अ विक्ट्री फॉर आवर ग्रुप which has contended that all these things are being done with an intention to stifle the proceedings and I quote Apostle Sangla, this is all mischief.
When you talk about ex party or decision will be this, so what happens to this now? So he is continued to take decisions, the district registrar.
In that first order High Court no direction dille ki district registrar will issue fresh show cause notice and conduct the inquiry. So आता दुसऱ्या गायलो जाल्यार it would have been a modification of that order कळ्ळें न्ही by the back door तो modify करूंक सोदताले. So the result is that same district registrar who issued that notice he is competent and entitled to continue with the proceedings. So he will do it. Now second question about ex parte. कोण कोर्टां येना जाल्यार order pass करूं जाय that I proceed ex parte.
कोण कोटा येना जाल्यार म्हणजे just
you either don't turn up or you don't file a reply
on that.
Yeah.
How many days it will?
The notice are permanent. That court that district registrar and take notice चे सांगलेले 4 तारखेर यो म्हण
2 weeks time म्हणलेलो पळय तो.
2 weeks आनी एक चान्स म्हाका दिसता आनी एक 2 चान्स दिल म्हण तेका न्ही 3 चान्स. So that is his discretion. We can't say ते दीस आयल ना जाल्यार तेका चॉप करपाचो तेस कोण कांय ना. So he has not come on that day. That officer, inquiry officer is like a quasi-judicial authority. So he can't act arbitrarily also. So he has acted fairly in giving them 2 more opportunities, total 3 months. So I think we will press that enough is enough. Put them to complete this thing. If they don't want to file a reply, we will have to go ahead with this.
So till what time they have to take a decision, district registrar?
2 weeks.
2 weeks, yeah.
By 18 of this month.
So overall if you see the whole scenario तुम्ही मध्येन पळयत जाल्यार ज्या भाशेन फाटल्या दिसांनी जें घडलां as far as this election procedure, the way elections have been conducted, they have gone to the registrar. So what could be the outcome now with this decision?
So I'll tell you something. First thing is, if a judge or a quasi-judicial officer has passed one order which for some technical reason gets set aside and the matter is remanded back, even to a civil court if it's remanded back, you can't make application, no he had already decided so he will be prejudiced, he will be biased. because a judge is expected to act fairly. So when the matter goes back, his order will be tested not on his past conduct, his order will be tested on that order which is written. What are the materials he considered, what are the materials he ignored, all that will be tested afterwards on a challenge calculator. So mere fact that he had passed a decision in our favor last time does not necessarily mean that he may agree with our contentions. He may disagree on hearing them, and he may say, I don't find case to interfere. Or if he says, despite your reply, I find that A, B, C, D is lacking, and therefore I find case to interfere, then he will hold it in our favor.